English shorthand 80 words per minute, passage number 29. Get ready. 10 seconds. 5 seconds. Start. The petitioner apprehends his arrest in a case under section 498A of the Indian Penal Code 1860, hereinafter called as IPC, and section 4 of the Dowry Prohibition Act 1961. The maximum sentence provided under section 498A IPC is imprisonment for a term which may extend to 3 years and fine, whereas the maximum sentence provided under section 4 of the Dowry Prohibition Act is 2 years and with fine. Petitioner happens to be the husband of respondent number 2, Shweta Kiran. The marriage between them was solemnized on 1st July 2007. His attempt to secure anticipatory bail has failed and hence he has knocked the door of this court by way of this special leave petition. Leave granted. In sum and substance, allegation levelled by the wife against the appellant is that demand of rupees 8 lakhs, a Maruti car, an air conditioner, television set, etc. was made by her mother-in-law and father-in-law, and when this fact was brought to the appellant's notice, he supported his mother and threatened to marry another woman. It has been alleged that she was driven out of the matrimonial home due to the non-fulfillment of the demand of dowry. Denying these allegations, the appellant preferred an application for anticipatory bail, which was earlier rejected by the learned sessions judge and thereafter by the High Court. There is phenomenal increase in matrimonial disputes in recent years. The institution of marriage is greatly revered in this country. Section 498A of the IPC was introduced with avowed object to combat the menace of harassment to a woman at the hands of her husband and his relatives. The fact that section 498A is a cognizable and non-bailable offence has lent it a dubious place of pride amongst the provisions that are used as weapons rather than shield by disgruntled wives. The simplest way to harass is to get the husband and his relatives arrested under this provision. In a quite number of cases, bedridden grandfathers and grandmothers of the husbands, their sisters living abroad for decades, are arrested. Nearly a quarter of those arrested for dowry death cases under this provision in 2012 were women, which depicts that mothers and sisters of the husbands were liberally included in their arrest net. Its share is 6% out of the total persons arrested under the crimes committed under Indian Penal Code. It accounts for 4.5% of total crimes committed under different sections of Penal Code, more than any other crimes expecting theft and hurt. Lawmakers and the police both know that arrest brings humiliation, curtails freedom and casts scares forever. But there is a battle between the lawmakers and the police, and it seems that police has not learned its lesson. The lesson implicit and embodied in the Criminal Procedure Code. It has not come out of its colonial image despite 6 decades of independence. It is largely considered as a tool of harassment, oppression, and surely not considered a friend of public. The need for caution in exercising the drastic power of arrest has been emphasized time and again by courts, but has not yielded desired result. Power to arrest greatly contributes to its arrogance, so also the failure of the judiciary to check it. Not only this, the power of arrest is one of the lucrative sources of police corruption. The attitude to arrest first and then proceed with the rest is despicable. It has become a handy tool to the police officers who lack sensitivity or act with oblique motive. Law commissions, police commissions, and this court in a large number of judgments emphasized the need to maintain a balance between individual liberty and societal order while exercising the power of arrest. Police officers make arrest as they believe that they possess the power to do so. The court believes that no arrest should be made only because the offence is non-bailable and cognizable and therefore lawful for the police officers to do so. The existence of the power to arrest is one thing, the justification for the exercise of its quite another. Apart from power to arrest, the police officers must be able to justify the reasons thereof. No arrest can be made in a routine manner on a mere allegation of commission of an offence made against a person. It would be prudent and wise for a police officer that no arrest is made without a reasonable satisfaction reached after some investigation as to the genuineness of the allegation. Despite this legal position, the legislature did not find any improvement. Numbers of arrests have not decreased. Ultimately, the Parliament had to intervene, and on the recommendation of the 177th report of the Law Commission, Section 41 of the Code of Criminal Procedure to be enacted. Stop.